Hello, I'm Chris Olson and I'm a reporter with Lawyers Weekly, and with me today is Jeff Pyle. Jeff is a partner with Prince Lobel Ty, and he is also one of the leading media and First Amendment lawyers in the Boston area. And I invited him here today to talk about President Trump's new front in his ongoing war with Twitter, this time in the form of an executive order that proposes a new approach to the Communications Decency Act. Jeff, welcome. Thanks for doing this.
Thanks for having me, Chris.
So just as an initial matter, let's sort of lay the groundwork for people who might not be as familiar with the Communications Decency Act, and of course the key section being Section 230 that we're talking about. What does that section say? What was it designed to do?
Sure. Section 230 was added to the law in 1996, right at the beginning of the internet age. And it derives from the fact that traditionally publishers of content, whether in print or any other medium, are liable for what they publish even if they didn't come up with it. So traditionally, if you wrote a letter to the New York Times or you placed an ad in the New York Times and that ad was defamatory or fraudulent or in some way legally actionable, then in some cases the newspaper or the publisher could be held liable for that speech. In fact, one of the great First Amendment opinions, New York Times versus Sullivan, which established a lot of First Amendment protections in the area of defamation law, that case arose from an ad that civil rights leaders had put into the pages of the New York Times. But the New York Times was sued and ultimately won at the US Supreme Court. In 1996, Congress decided that rule that a publisher is liable for the content of the ad, even if the publisher didn't write it, that rule wouldn't work in the internet context. Even back in 1996, there were millions of posts on message boards every day. And Congress knew that if that kind of liability were imposed on internet publishers, then internet publishers would either be draconian in what they decided to block and filter out, or they would simply not publish at all. And in fact, some court decisions had held that if the online platforms, filter and block content to any degree, then they're liable for their choices. And so that would create a potential incentive for a free-for-all online where nothing is blocked or filtered, because that would be a way for platforms to avoid liability. So they passed Section 230. And Section 230 says in very simple terms, a website is not liable for content posted on it by a third party. That's really all you need to know about what Section 230 does. It says that Twitter or Facebook is not liable if, to take a hypothetical example that has no bearing on reality, somebody posts that a former congressman 20 years ago killed an employee in his office, and that statement is false and defamatory, then Twitter cannot be held liable for the fact that a user of Twitter posted it. The person being defamed, in my case, obviously Joe Scarborough, has to sue the author of the tweet, Donald Trump himself, not Twitter.
Gotcha. And so I take it then that Section 230 has sort of done what it was supposed to do, given the fact that we now have these behemoth social media sites that have been able to grow and flourish and so forth.
Well, it's done what it was supposed to do in the sense that, yes, we have a vast array of user-generated content online and millions and millions and millions of posts that are uploaded every single day. It's also done what it was intended to do in the sense that it has protected web platforms when they block and filter content. I mean, Facebook and Twitter do both have rules about what violates their terms of service and what doesn't violate their terms of service. And they apply them. They have moderators. They have automated filters that filter out content. And what Section 230 does is says that when you decide to exercise those kind of editorial functions, you're still immune from being sued for exercising that editorial function, so long as the content that you're filtering comes from a third party.
And so I guess let's turn a little bit to the executive order here. And I guess sort of the first question is, I mean, one of the things that President Trump wants to do or suggests is needed is that there needs to be this new approach or that there needs to be a clarification of Section 230. Do you agree that there needs to be some clarification here?
There's no clarification needed to Section 230 because the federal appeals courts have been unanimous in giving it really broad application. They have said that even, for example, when you're charging that a website was negligent in failing to weed out harmful content that harmed other people, they have said you cannot get around Section 230's immunization of filtering and blocking and editorial choices by attacking the structure of the website or attacking business choices the website may have decided to make. There's no circuit split, there's no ambiguity, there's no outstanding question of law that hasn't really been decided in the context of Section 230's protection against liability for third-party content. No, what the president's executive order is trying to do is trying to rewrite Section 230 by executive order, and that, of course, is not permitted.
So, I mean, I guess even just generally, I mean, we're now sort of close to 3 or more than 3 years since the Trump presidency. There's been a lot of things that have been bluster that turns out to be kind of idle talk, a lot of tough talk, and it doesn't go anywhere. And then there's other pronouncements that actually do have some real world implications. Do we know sort of yet which one of these two this executive order might be?
This executive order seems to fall into the former category of the president having a temper tantrum that looks like it's actually some kind of meaningful action. And in most cases, and for the most part, this executive order does not actually do anything meaningful except send a message. And I'll get to that in a minute. One of the things it does is ask for an agency to petition the Federal Communications Commission, which is an independent agency, to consider clarifying Section 230. Well, the FCC has not been given any role by Congress in terms of Section 230 jurisprudence. There's been no directive from Congress. And when an agency is supposed to make rules, it has to do so at Congress's direction, not an executive order. And the FCC has sworn up and down already that it's not in the business of policing neutrality in the internet space anyway. So it's unlikely, most commentators think, that the FCC will actually take up or do anything in response to this executive order. He's also asking, the executive order also says that the FTC will be asked to police decisions made by tech companies in terms of what they block. It calls censoring online content. It's not a government entity. They can run their platform however they want. But the FTC is being asked to look into whether some of these entities are violating their own terms of service or their own representations to consumers. I doubt that terribly much mischief is going to be caused by that in the real world, because the FTC, no online platform promises somebody in their terms of service that we're never going to filter or block your content. Or most of them probably don't even say we're going to be politically neutral, because if they said that, then they'd have to give an equal platform to the American Nazi Party as they do to the Republican Party. So it's unlikely that any of that stuff with the federal agencies is going to lead to much. One thing it does do that is unconstitutional and is likely to lead to litigation in the future is that the president's executive order directs effectively federal agencies to review their advertising spend on social media platforms, and it strongly encourages them, I would argue, to not spend any advertising dollars on platforms that he doesn't like their moderation practices. Well, that could lead to a First Amendment violation by the platforms themselves, because it's unlawful to retaliate against a person or a corporation on account of their free speech. And this executive order mentions Twitter several times. It was plainly directed at Twitter and its decision to fact check one of his false tweets about vote by mail. And so if ads get pulled from Twitter, then Twitter could very well have a First Amendment cause of action. I should mention that just yesterday, the Center for Democracy and Technology filed a lawsuit to set aside this executive order, arguing that it's ultra vires and in violation of the First Amendment, and focused on the chilling effect I would say that this kind of an action can have on web publishers. It's essentially saying, if you don't do what the president likes in terms of content moderation, if you don't allow his propaganda to go unchecked, then you're going to get harassed by all these different federal agencies, and we're going to come down on you. That is a troubling message to send to web platforms or any other user or facilitator of online speech, because it's exactly contrary to what the First Amendment is about. The First Amendment is there to protect us from government regulation of speech. Donald Trump would like to have government regulation of Twitter so that his lies can get broadcast with impunity to the whole world.
I mean, have you digested that suit to a degree to be able to assess how effective it's likely to be and what challenge that might face?
No, I wouldn't say that I've looked at it totally fully. It was an interesting cause of action. It's brought under the All Writs Act, which I've never pleaded in a complaint before. I don't know what the chances of success of that lawsuit are.
Are we likely to see other lawsuits potentially, or do we have to wait until something actually happens before?
I should think that we're likely to see other lawsuits both before and after something happens with regard to this. And I don't have a crystal ball about it, but I would think that pulling ads from places that Donald Trump doesn't like in retaliation for speech would be a good fertile ground for litigation in the future against this stuff.
We talked a little bit earlier about the FTC, but I think in the executive order, Trump at least envisions states' attorneys general also getting involved in these so-called unfair and deceptive practices. Is this going to be just another partisan matter where Republican attorneys general sort of take up the mantle and Democratic attorneys general don't follow what Trump is trying to do?
Well, unclear, although it's certainly a possibility. One of the things that bothers me about the executive order is that the Attorney General of the United States is being asked to review the censorship, so-called practices of some of these platforms and make recommendations. And it wouldn't surprise me at all if the Attorney General already has or will soon be issuing subpoenas to some of these platforms to get oodles and oodles of documents and information about their content moderation practices. That could be a real administrative burden on a lot of these sites. And let me point out too that when you start having the government throw its weight around against tech companies, it's often not going to be the big companies like Twitter and Facebook that are going to be most affected. They have the resources to hire content moderators. They have armies of lobbyists and political consultants who can help tamp down some of the worst excesses of this stuff. It's going to be smaller companies, the upstart companies that are trying to actually take a little bit of the share away from Facebook and from Twitter, that could be most impacted by any retrenchment on Section 230's liability protection or any imposition of some new sort of political test to moderation practices. I want to encourage other platforms to be out there because most Americans are actually, I would say, dissatisfied with how social media has affected our politics in general. To the extent other platforms with different ideas about how to present information to the public and how to avoid some of the divisiveness that we've seen generated from Facebook and other platforms, that would be a welcome development, and we shouldn't do anything to try to stop that from happening.
And of course, I've read, obviously Trump sort of put this front and center, but I found it interesting that even his would-be Democratic challenger, Joe Biden, has said in some media interviews that he's in favor of repealing Section 230.
He did say that in January, and I understand he's walked that back a little bit since then. There's been plenty of bipartisan anger at tech companies, and Democrats have been understandably upset at the decisions of especially Facebook not to do anything about political lies on their platform. Twitter has banned all political ads on their platform, but Facebook still accepts political ads and allows them to be micro-targeted in ways that Democrats consider to be unfair. There are much less speech harmful measures that one could imagine taking beyond repealing Section 230 in its entirety that would be better than what the sort of the knee-jerk reaction has been to say there shouldn't be any liability protection at all.
Right. I mean, do you have some suggestions? I mean, I know Twitter has gone, to this, this fact check where, they flag something and link you to another piece. And I think there's been a lot of debate over how effective that is, whether or not people will actually click through and read, and whether that completely undoes whatever harm the original tweet allegedly has done. Do you have other ideas that you think might either be more effective or consonant with the First Amendment?
Well, my only criticism of what Twitter did with its fact check tweet of Donald Trump was that it probably didn't go far enough. Its little tag said, "Get the facts about mail-in voting." It didn't directly suggest that Trump's tweet was false. And I'm not against the idea in cases of big social media, big accounts that are followed by many, many millions of people and that are obviously influential, of Twitter and other platforms tagging these things in more explicit terms to say, this tweet is warning, this tweet is false. They have gone this step of issuing a warning label on a tweet that incites violence, but allows anybody who wants to see it to still see it. Frankly, I think it's well within platforms' right to remove tweets and posts that they determine do promote violence. They are allowed as private companies to have the rules that they want on their platforms. And I think some of them ought to be doing more to filter and block content. And that, after all, is what Section 230 was enabled to allow them to do, to filter and block content without being held liable for it. They should also not be subjected to bogus executive orders that are trying to impose some kind of political test on whether or not a platform is acting appropriately. That's a method of sending out propaganda. It's not a method of protecting free speech.
You at least give Twitter some credit for at least trying. I mean, it seems like Facebook's attitude is completely hands off, anything goes.
I do give Twitter credit for that. I think it was a brave decision because I think that they knew that they were going to elicit the ire of the president. So kudos to them for beginning the process.
Well, I mean, this probably won't be the last conversation we'll ever have about social media and the places that it's taking our political discourse. But I appreciate you giving us some insight into the executive order.
Thanks, Chris. It's been a pleasure.